Good evening. My name is Isa Mester, and I'm a student project manager at the Clark Forum for Contemporary Issues at Dickinson College. On behalf of the Clark Forum, Penn State Dickinson Law, the Center for Global Study and Engagement, and the Departments of Environmental Studies, International Studies, and the Law and Policy Program, I would like to welcome you to tonight's event, The Canary in the Coal Mine, the 1951 Refugee Convention, and the collapse of the post-World War II international order. At this time, I ask that you please silence all cell phones and other devices. In the event of an emergency, accessible exits are located through the door behind me. There will be a question and answer session immediately following the program, so please hold all questions until that time. During the question and answer session, we ask that you keep questions succinct so that everyone who wishes has a chance to ask their question. As a show of respect for our speaker and everyone in attendance, please stay until the end of the program, including the question and answer session. Before we begin, I would like to take a moment to acknowledge that Dickinson College is on the unceded lands of the Susquehanna Nation. We acknowledge the many indigenous peoples that lived with these lands, as well as the thousands of indigenous children forced into the Carlisle Indian Industrial School starting in 1879 as part of a federal cultural eradication effort. I would like to highlight the fact that tonight's program was student-initiated. At the beginning of each semester, the Clark Forum student project managers proposed two programs that we developed for the next semester. This event grew out of a course I took while studying abroad, Fleeing Across Borders, International Refugee Law, which sparked my interest in the challenges of refugee protection and led me to propose tonight's discussion. Growing up in Germany, refugees have been an ever-present topic in political discourse and media coverage. Since the 2015 quote-unquote refugee crisis in Europe, immigration policy has played a critical role in electoral politics as it becomes progressively more restrictive. At the same time, news coverage continues to document escalating humanitarian crises and displacement worldwide. This tension between increasingly exclusionary policies and growing humanitarian need raises critical questions about how Western states interpret and fulfill their legal obligation toward refugees. Understanding this paradox is essential to assessing both the realities faced by displaced individuals and the commitments embedded in international refugee law. Tonight, Professor Seyla Benhabib will explore the promises of the 1951 Refugee Convention and the challenges facing that framework today. As states adopt policies such as externalization and non-entry measures, new legal and political dilemmas emerge, prompting broader questions about the durability of the post-war international order and the future of refugee protection. Seyla Benhabib is Professor Emerita of Political Science and Philosophy at Yale University and a Senior Research Fellow at both Columbia Law School and the Center for Contemporary Critical Thought. She previously served as president of the Eastern Division of the American Philosophical Association and has been a member of the American Academy of the Arts and Sciences since 1995. In 2017, she was elected a corresponding member of the British Academy of Social Sciences and the Humanities. Earlier in her career, she taught at the New School for Social Research and at Harvard University, where she was a professor of government and chaired the university's program on social studies. Professor Benhabib has received numerous prestigious honors, including the Ernst Bloch Prize, the Leopold Lucas Prize from the University of Tübingen's Theological Faculty, the Meister Eckhart Prize, the Adorno Prize, and the Hannah Arendt Prize in 2025. She has also been awarded a Guggenheim Fellowship and has held research and senior scholar positions at institutions across the United States and Europe, such as Berlin's Wissenschaftskolleg zu Berlin, the NYU Strauss Center for the Study of Law and Justice, and the European University Institute. Her recent publications include At the Margins of the Modern State, Critical Theory and Law, and the co-edited volume, Lawless Zones, Rightless Subjects, Migration, Asylum, and Shifting Borders, created in collaboration with Ayla Shah of the University of Toronto. And now, please join me in welcoming our guest, Professor Seyla Benhabib.
Thank you so much for this kind introduction, and thank you very much to all the sponsors of this lecture, the Clark Forum, Penn State Dickinson Law Center for Global Study and Engagement and International Studies, and a few others which I have not mentioned. I've had a wonderful day so far in your campus, and the summer seems to have emerged as well. So let me begin with a few general observations. Canadian Prime Minister Mark Carney's speech at the World Economic Forum on January 20, 2026 was the most lucid statement yet by a world politician of the current condition of global politics. Carney said, quote, "We are in the midst of a rupture, not a transition," and I'm sure many of you are familiar with this phrase. As geopolitical rivalry intensifies, territorial grabs by war and other means spread, and as the United States in particular withdraws from multilateral institutions it was once so influential in creating, Carney rightly observed that the so-called rule-based international order of the post-World War II era is over. A rupture, as opposed to a transition, has no designated endpoint, and Mr. Carney wisely abstained from future predictions, recommending instead a cautious realignment of middle-sized powers and multilateralism. I want to argue in this lecture that this rupture was already latent in the fraying of compliance by states with some of the major international law agreements of the post-World War II era, and in particular with the 1951 Refugee Convention, my focus tonight. But before I go further, let me clarify that I'm a political philosopher and that my main interest for much of my life have been German philosophy and the work of the Frankfurt School, especially Jürgen Habermas, now deceased, and of course also Hannah Arendt. In 1996, I published a book on Hannah Arendt called The Reluctant Modernism of Hannah Arendt. And it struck me that one of her deep legacies for thinking about politics in our century was her phrase, "the right to have rights." Arendt had herself been a refugee for 18 years, and in The Origins of Totalitarianism, she wrote that the right to have rights remained the unfulfilled promise of nation states, and maybe the unfulfillable promise of nation state politics. In 2004, then, I wrote a book called The Rights of Others, Aliens, Residents, and Citizens. And at the time, I was living in Europe, and I'm mentioning all this because, interestingly enough, in much of the conversation during the lunch, this has come up as well. I was living in Europe, and in much of Europe, but in Germany in particular, where I was living, the fate of the refugees from the Yugoslav War, 1991 to 2001, on the one hand, and the growing number of so-called guest workers, and the fate of the third generation children, on the other, was putting citizenship and nationality issues on the agenda. Germany finally revised its citizenship laws, such as to permit the nationalization of children born to foreign parents, at least one of whom had been a resident in Germany. At the age of 24, these young people could become citizens. Dual nationality was not permitted at the time. It is now. My focus on the rights of others had been cosmopolitan and post-national citizenship. The refugee question emerged later in my work For the last 7 years, I've been teaching a course at Columbia University called Migration, Citizenship, and Refugee Law in Comparative Perspective. And what I'm going to share with you tonight is going to be results of my teaching and research. 1951 Refugee Convention, and you can tell how international law emerges. Okay. Now, let me begin with a general observation. The concept of the refugee is actually an older concept than the citizen. All major world religions and ethical theories recognize the refugee as the one who comes to our shores and who seeks help from us. We were all strangers in another's land. So in the Bible, we even have the concept of the cities of refuge. The term refugee comes from the historical episode of the Huguenots who fled to England in 1685 after Louis XIV revoked the Edict de Nantes that had given liberty to French Calvinists in 1598. So the Huguenots were French Calvinist French Protestants who then fled to England. So that's the origin of the term refugee. Now, the 1951 Refugee Convention, I know that some of the writing may be a bit small on the screen, is grounded in Article 14 of the Universal Declaration of Human Rights, 1948, which recognizes the right of persons to seek asylum from persecution in other countries, and the United Nations Convention relating to the status of refugees is the centerpiece to this day of international refugee protection. Article 14 of the UDHR, first paragraph, says, everyone has the right to seek and to enjoy in other countries asylum from persecution. This right may not be invoked in cases of prosecutions genuinely arising from non-political crimes or from acts contrary to the purposes and principles of the United Nations. And if you're a war criminal, you cannot be offered refugee status. The convention entered into force on April 22nd, 1954, and it has been subject to only one amendment in the form of a 1967 protocol, which removed the geographic and temporal limits of the 1951 convention, because the 1951 convention was limited to events happening in Europe before 1951. The 1967 protocol amended this and globalized the refugee definition beyond 1951 and beyond the geographical limitations. A refugee is a person who, as a result of events, this was the original formulation before January 1st, 1951, no longer relevant. A refugee is a person who, owing to well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality and is unable, or owing to such fear, is unwilling to avail himself of the protection of that country. Or, this is law, not having a nationality and being outside the country of his former habitual residence as a result of such events is unwilling or unable to return to it. In other words, a refugee may be someone who is in the country of their quote-unquote origin or habitual residence, and this is important because many refugees are people, or there may be ones who have fled their own country and have lived for a number of years in another country before finally seeking refuge in a particular country. So it's, from the standpoint of the law, it's important to specify that there can be many ways in which a refugee can be a refugee. So this is ratified by 149 state parties. But there are some surprising exceptions, and some exceptions that are consequential for world politics. In the Middle East, Iraq, Lebanon, and Jordan are non-signatories. And of course, given the number of Palestinian refugees in Lebanon and Jordan, this is important, but I'll mention in a second the special status of Palestinian refugees. Iran, Egypt, and Israel are signatories. Most Gulf states are non-signatories. In South and Southeast Asia, again surprising, India, Pakistan, Sri Lanka, Malaysia and Indonesia are non-signatories. Now, the fact that India and Pakistan are not signatories is extremely important because they were having their own partition war in 1948, and they felt that the 51 Refugee Convention in no way really spoke to them, to these issues. We also have Eritrea, Libya, Mongolia, Cuba, Uzbekistan, Guyana, etc., as non-signatories. Now, the uniqueness of the convention is that there is no single authoritative entity to resolve interpretive questions. There is no international court, tribunal, or authority, unlike the Universal Declaration of Human Rights, where there is a Human Rights Commission in the United Nations, and states and other parties can pose questions, and they are interpretive, authoritative judgments. The Geneva Convention doesn't have this, but what it has is the United Nations High Commissioner for Refugees that has the duty to supervise application and provisions of the convention, but no authority to mandate a specific interpretation of it. Now, going into the weeds just a little bit, there is a distinction, very important distinction, between alienage versus internal displacement. A refugee must be someone who crosses international borders, either from her state of nationality or, quote, habitual home. Internally displaced persons do not cross international borders. But then the biggest example here are the Rohingya in Myanmar, right? Myanmar says they don't belong to us, and they can only be refugees when they go over to Bangladesh. But what law protects the Rohingya when they are in Myanmar? They become, quote unquote, objects of humanitarian concern. And there was this attempt to develop the so-called R2P for protection, but this was quite, this became controversial. One further distinction, and this area is full of distinctions that may seem counterintuitive to many of you, okay? From an ethical point of view, political point of view, but the refugee law operates with these distinctions. And a difficult one is statelessness versus being a refugee. Now, this almost a bit of a mind twister. You can be de jure stateless, that is to say, you can be denaturalized, okay? One of the most famous examples is the denaturalization en masse of German Jews after Hitler's ascent to power, including, let's say, someone like Hannah Arendt, who was already in Paris at the time, but who loses German citizenship and becomes de jure, a by-law, stateless. And there are also individuals who are de facto stateless, like the Rohingya refugee, because the state does not recognize them. According to various counts, there are 10 million people who are stateless in the world. But a very careful effort was made during the signing of the 51 Convention not to be responsible for the stateless and to distinguish the refugee from the stateless. And in particular, the United States representative, Louis Henkin, who taught international law at Columbia, was a very important voice in this because the United States did not want to assume obligation for all stateless persons in addition to the refugees. And subsequently, what happened was that there was a convention relating to the status of the stateless and the reduction of statelessness, but it still has not been that effective in the world. Let's come now to some more terminological issues. I know this is, at first, as I said, somewhat counterintuitive and difficult if you're looking at it from the outside. The United Nations and most organizations dealing with refugees now use the language, prefer the language of forced displacement. As of 2025, there are 117.3 million people displaced worldwide. Okay? Of these people, 42.5 million are refugees. That's to say, about less than half of these individuals have crossed international borders. That's what makes them refugees. 67.8 are internally displaced, which is an important figure, which means that continuing civil war and conflict, okay, Syria, the Congo, Sudan, are creating large numbers of individuals that are not crossing borders, but that are internally displaced. The UN, the Refugee Convention, this website cites 4.4 million stateless. And let me say something about UNRWA, United Nations Work for Refugee Protection. This has a special status, this organization. And as you may know, at the end of or during the Gaza war, Israel refused to recognize the international status of UNRWA, and I think both the United States and Israel no longer accept UNRWA. Now, although there is a language of crisis, being run over, being inundated by criminals, our country is being taken over, etc. Although there is this language in Europe, in North Atlantic countries, including a country like Australia, etc., the host countries, the countries that harbor most refugees, are not in the global north, they are in the global south, if you want to use that terminology. And this is one of the ironies of refugee protection. Colombia, Iran, very large number of Afghani refugees in Iran. Germany, Turkey, and now increasingly Uganda. Germany is the only European country that comes close in number to the refugees being protected. They are with about 900,000 or so refugees. So this is, again, an important fact to keep in mind, to understand, or maybe, to sort of think about what is behind the language of crisis and the language of fear that is so often generated in this discussion. Let me now talk a little bit more precisely about different refugee regimes. Because the Refugee Convention interacts with other forms of international law and with other forms of international organizations. The most important at the current period domain from both a legal and political point of view is the refugee regime in the European Union under the European Convention for Human Rights. Now, the European Convention for Human Rights is a convention, it's international law, in which non-members of the EU, such as Turkey, are included. It has 46 member countries, so the UK remains a member, although it's withdrawn from the European Union. And some of the most influential asylum cases, both politically and legally, of recent years are cases that have been formulated or decided by the European Court of Human Rights. I don't think we have enough time in the lecture for me to go into the specifics of all this, but let me mention a couple. Hirsi Jamaa and others versus Italy. Now, this is a case where a group of over 100 refugees originating in mainly African and North African countries were, encountered an Italian ship on Italian maritime waters. According to UNCLOS, United Nations Convention on the Law of the Sea, when a boat that wears the flag of a specific country encounters a group of refugees at sea, the obligation is to pull that boat, to bring it to safety in its own waters, or to bring it somewhere else where they would be offered refugee protection. And Italy at the time complied with UNCLOS, but in bringing these refugees, it placed them, actually returned some to Libya, with which Italy has a bilateral agreement. But in the process of this, in this process, a number of refugees died. About 13 or 15 of them went missing. And that's when the European Court of Human Rights judged against Italy for violating the European Convention on Human Rights. Since then, Italy has enlarged its cooperation with Libya so that now actually the Italian Marines and so on no longer patrol the Mediterranean. Think your geography, right? Italy, Libya, Mediterranean. And they no longer patrol the Mediterranean. Instead, now what Italy is doing, unfortunately, is using drones to identify refugee boats and frigates on the Mediterranean and actually informing Libyan patrol boats. I mean, it's amazing that this agreement continues to go on. I'm not going to go into the details of ND and NT. There is a picture in a second I'll show you. This case is important because this is the one land crossing, the country in Europe that touches Africa territorially is, of course, Spain, and there is a huge rigmarole about this area called Melilla and Ceuta, whether in fact this is in Spain or in Africa, and what happens when African refugees come over the border, and at what point are they in Spanish territory. So Mediterranean sea vessels, number of deaths since 2024, I say one of our colleagues gives 67,000 have disappeared or died. We, in our book with Aile Shahar, we cite the figure of about 13 to 34 dead. And these are the various bilateral agreements of refugee regimes. Now, what are states doing? One thing that states are doing is they are building walls. Walls serve the illusion of gaining control over immigration. They are attractive, visible, concrete, right? The beautiful southern wall. It's easy for the state. The state asserts its authority visibly. In building the wall, the state shows that it is doing something. It's it's a symbolic space. Now, this is what I was saying a minute ago, Ceuta, Melilla. These are the Spanish guards helping migrants climb down. These are migrants from Morocco crossing over, coming to Spain. There are 3 walls here. As you can see, this is barbed wire. And only if the refugees manage to get past the 3 walls and end up on the other side, probably with gashing wounds in their leg, are they considered to be part of on the European territory. This is the West Bank barrier in Israel. And this is the famous Mexico-US fence. Barriers look much like each other. There cannot be that variation. So, why are the states building walls? What are the states doing? So, I want to distinguish this part of my analysis into 2. One is state behavior, which I'm going to return to in detail. The other is difficulties in the implementation of the convention. The convention says a refugee is a person who, owing to well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion. One criticism that has come mainly from representatives of refugee organizations and so on in the global south has been that this is an extremely individualistic definition, right? And it does not consider that refugees migrate in families, in groups, in neighborhood, etc. So this has been one issue, the individualistic bias of the convention. The second has been, how do you prove well-founded fear, the so-called credible fear interview that the refugee has to undertake or has to be subjected to when they arrive? The amount of documentation required, okay, under conditions of fleeing from persecution, what kind of documentation can you bring with you? I mean, this goes to absurdities, particularly in the event about women, okay? And that's because one of the students said, Professor Benhabib, have you given up feminist theory? I haven't. I'm just trying to sort of, you have to see the ways in which it mixes. And here's an example. Women coming particularly from conservative, more observant cultures have difficulty in the credible fear interview if they have been subject to sexual violence. They don't want to talk about it. They don't want to admit it. They don't want to state what happened to them. This is a cultural taboo. And so, it requires enormous sensitivity and some understanding of not only the law, but some understanding of human culture to carry out these interviews. That's why it's very important not to just throw CBP agents at them, okay? You know what I'm talking about. It's important that they be trained, okay? So the amount of documentation required and the grounds of persecution. Now, in response to this, regional refugee agreements have emerged. From an organizational point of view, the most important regional agreement is the Cartagena Declaration of 1984. And they argue that refugees are persons who have fled their country because of their life, safety, or freedom have been threatened by generalized violence, foreign aggression, internal conflicts, massive violation of human rights, or other circumstances which have seriously disturbed public order. Now, you can see here how the definition of the grounds of persecution are becoming generalized, and what kinds of legal questions this may raise. I'm not going to talk about non-refoulement as use coke, and some of you will ask me about it in the question period, but let me just go on. There is a second regional development, and that is the Organization of African Union that adopted a different migration policy and framework, the goal of which is, again, to reduce this insistence on the individual culpability of the refugee and to accept that refugees are individuals coming from generalized conditions of violence. Okay, so there is that difficulty with the individualism of the convention, the amount of documentation required, how to prove the level of violence. Now, another interpretative difficulty, what constitutes a convention refugee? How are these criteria, race, religion, nationality, membership of a particular social group or political opinion, to be specified? Particularly for those of us who come from social sciences and the humanities, in the recent decades and so on, constructivism as a methodology has been so important and teaching us that we have to look at these categories as emerging out of social historical, cultural, anthropological studies. And yet, it seems as if the law is working with a framework of categorization. I mean, most of us would find to distinguish between, what do they mean by race? What are we talking about? Color, culture, genetic, what exactly? Now, another category, membership of a particular social group. Apparently, this emerged, it's a very vague category. This emerged as a group, as a category, because the Swedish representative to the convention said, look, the Nazis did not only persecute the Jews and the Gypsies and the Roma and the homosexuals, they also persecuted differently abled people. So we need a category for this. Okay? So membership of a particular social group. And interestingly, in recent years, the most creative, interpretive work in law, in refugee law, has been done around this group, around this category of particular social group, which has now been open to gender-related crimes. Everything from female genital mutilation to sexual slavery, etc. So, through the creative, interpretive work of lawyers, some categories that could have been hardly imagined in the '51 Convention have come through, and Canada recognizes gender-based violence as a convention ground, and now also within the European Union, increasingly sometimes called gender apartheid, is being used as a category, and in particular, this helps Afghani women, refugees, in their claims. And here we come to one of the major stumbling blocks, divisions in the convention. And a couple of you raised this question with me already during lunch. And it is indeed a very difficult one. The Refugee Convention is based on a very hard and fast distinction between the economic migrant and the political refugee. In many countries, if you just say, oh, she's an economic migrant, you have delegitimized that person's refugee status. And this seems impossible, because economic deprivation is also a form of persecution. You can be economically deprived because you are a member of an ethnic group or because you are a member of a religious group. So it seems as if this separation and the way in which it is made is one of the many stumbling blocks now in the convention. And one of the most important contributions to this debate has come from Tendai Achiume in an important article called Migration as Decolonization. And she points out to this binary. She says, the third world migrant, many have had experiences comparable to that of a refugee. But they are individuals that have initiative and desire for self-enhancement, and they cannot simply be defined as victims. And she makes the most important argument that freedom of movement is a decolonial move. Right? And it's a decolonial move because, in a sense, it reflects the interdependence of economic development. Just as Europe extended and colonized the rest of the world in the 16th and 19th centuries, and these economic developments cannot be thought of in separate terms, Achiume argues that to define refugees as political strangers, but to accept the obligation that one has to them does not take into account all the economic interdependencies that colonialism and imperialism produce. A lot more needs to be said about this because it's not clear how, in legal categories, etc., how this can be operationalized. And of course, climate refugees, about whom I'm not going to have a chance to say a lot, but we can discuss it, are an interesting in between. Who are they? Are they migrants? Are they refugees? So let's come back to the question. What are the state responses to convention obligations? As I said, state reactions are occurring both in response to the intrinsic difficulties of interpretation and implementation that the convention has, and also states are governing their own interests. So states are developing walls and what is referred to as non-entree techniques, no entrance, right? Seawall in San Diego, California. What are some of the non-entree strategies? I'm looking at blue. The most extreme case was provided by Australia, which in response to a lot of refugee boats coming from Afghanistan, simply excised some of its territory and declared the Rushmore Islands no longer Australian territory. So the state withdraws, says, this is not my grant, it's not my obligation. Or states create zones of extraterritoriality, as is Guantanamo. I mean, we know about Guantanamo from many other perspectives, but Guantanamo was one of the first pieces of US territory onto which Haitian refugees were deposed who were not admitted into the United States. So there is an attempt to create extraterritoriality. Now, Guantanamo is peculiar because it is a piece of territory on Cuba that's been rented to the United States for 99 years. It is not part of US territory. But still, there is a debate. Does US law apply? Of course it applies. So if it applies, then what is the status? What was the status of the Haitian refugees in this very famous case called Asylum? But increasingly, states are creating more and more extraterritorial zones. Airports, international airports, are becoming this ambivalent hybrid places, okay? Suppose you come from Afghanistan, you are in Frankfurt airport, and you say, asylum, okay? Under the convention, it seems as if at that point in time, you should be taken and given a credible, fair interview. That's not what's happening. What's happening is that you're being told that you are, in effect, not on German territory, not in the European Union. So you are ending up in this kind of no man's land, and if I may use that terminology. So this is increasing. We deal with this extensively in our book with Ayelet Shahar. Now, let me say something briefly about what's happening in the United States. Of course, the whole lecture could have been devoted to that, and much needs to be said. But I want to enter this discussion through the question of state behavior, extraterritoriality, etc. And I want to show, in a sense, how the United States is no longer a country of refuge, or getting there. Now, Immigration and Nationality Act of 1965, I believe, respects the category of the refugee, and the United Nations is a member of the convention. With the Refugee Act of 1980, this is again solidified in law. So the 1951 refugee law is also the law of the United States. But there are a couple of ways in which the United States refugee definition differs from the conventional definition. So this is, I'm quoting from the Refugee Act of 1980. The term refugee means any person who is outside any country of such person's nationality. This paragraph, okay, this paragraph until B repeats the language of the convention. Now, B is peculiar to the United States. In such special circumstances as the president, after appropriate consultation, as defined in Section 207E of this Act, may specify any person who is within the country of such person's nationality, or in the case of a person not having nationality, within the country in which such person is habitually and who is persecuted, etc., as a refugee. That is to say, the United States has this is very, very interesting, that in effect the United States can designate a person as being entitled to asylum status even though they are not within the territory of the United States. What are we talking about? Let's take some examples. Many Afghanis who during the invasion of Afghanistan helped United States either via military involvement or more likely with translation, intermediation, etc. These individuals are entitled to refugee status in the United States. Not just Afghanis, I mean, if there was the Vietnamese boat people in my generation, probably not known here to the students, but to some of the faculty. The United States government has the discretion to use refugee status also as part of its foreign and diplomatic policy. And what happens is that every year, Congress, with the president, there is a number of refugee number being designated. Yeah? For many years under the Biden and Obama administration, this was about 50,000, and it increased. Under the Trump administration, I have seen that the number of refugees being admitted to the country is something like 300,000. 300, I'm sorry. And many of them are probably, the ones coming from South Africa that supposedly were given special status. So the president is no longer, exercising this prerogative. But even more than that, a lot is happening. There is a very well-known case called Al Otro Lado versus Nielsen. Al Otro Lado is an organization of civil society groups, legal groups that are suing the Secretary of Homeland Security, and it was Secretary Noam. We'll see, Now, what is being claimed here in this case is whether the government may nullify the Immigration and Nationality Act's asylum and inspection requirements by stopping asylum seekers inches before they cross the border at a port of entry, right, in the southern border, and turn them back to wait in Mexico. This has been actually practiced by both Democratic and Republican administrations, that refugees are being issued pieces of paper with an appointment, let's say, and being said they're not being permitted into the United States territory, but they're being told to come back for a credible fear interview. This is called metering. And the Biden administration has used it as well as the Trump administration. But what's happening now is not only that they are being, that metering is being applied, but that someone who is stopped on the Mexican side of the port of entry is now, it is said that this person has not really arrived in the United States. And because they have not arrived in the United States or set foot on US soil, CBP is claiming that they do not have asylum processing requirements, that they don't have to give a credible fear interview. Okay? So this is one step further than metering. Metering accepted that that person had a right to asylum and just told them to come at a certain time. What's happening right now, we don't know, the case hasn't been resolved. It's being said, you are not on the United States territory. We do not have an obligation towards you. This raises the whole question of territoriality versus jurisdiction in legal terms. And I will just observe, and I will just conclude by saying that increasingly in legal scholarship, it is not territoriality that is the trigger, or let me put it carefully, it is not presence on a territory that is the trigger of convention obligations, but it is jurisdiction, meeting with a certain official, okay? So if, in effect, the refugee encounters an official exercising a certain jurisdiction, then what is relevant for the obligation of the state into which the migrant is trying to enter is the exercise of jurisdiction, right? This is almost analogous to the migrant encountering the boat of a state carrying the flag, right? And then having jurisdiction. So this is, along with the birthright citizenship case, this is another case in front of the Supreme Court. And for many of us, maybe it may seem like being at is not being in. That's what's being debated in the court. So let me conclude. At its 75th anniversary, some of the difficulties emerging are consequence of interpretive challenges such as convention categories, credible fear, and others arise because of transformation in the world economy. I mean, after all, we are living after 2 decades of global financial capitalism, where tourism, transportation, communication have become global flows and are just simply easier than they had been before. But in a global world where everything seems to move at the touch of a click, money, news, fashion, images, the human body is controlled. The human body, as I say, is the site where the state exercises and shows its power. States also act as clever actors to circumvent their obligations by building walls and engaging in non-entry tactics. Why should states cooperate? I mean, this is a large question. Why is a rules-based order desirable to the situation that we have here now, where increasingly more and more exceptions are making, such holes in refugee obligation? First, let's not be naive about it. There is self-interest. A lot of countries in the global north are facing aging populations, and they simply need labor power. And even if, there is the distinction between the migrant and the refugee and so on, the refugee movements and migratory movements are also an aspect of the global economy. Then second, civil society pressures. And these emerge because family unification, about which I haven't said much, is one of the most important motives also in the movement of migrants and refugees. So, of course, civil society does not just consist of families. There are many NGOs, INGOs, and there is also increasing consciousness, as we have seen in the case of Minneapolis-St. Paul, where individuals have come out in defense of their neighbors. There is the texture of everyday life that these developments have created, and taking them apart, it does violence to these communities, right? And people have been willing to resist. Why should states cooperate? Well, again, they cooperate in those regions of the world, and they acquire influence and diplomatic prestige, but also, friendship and mutuality. These are not very, very strong grounds, and there's a way a rules-based order protects self-interest and does not necessarily diminish it, right? I mean, as Tocqueville said, self-interest properly understood. And I think that in the case of defending something like the Refugee Convention, in as much as we may just want, to list the legal grounds. I mean, the Kantian in me says, who cares what self-interests are of the state? But on the other hand, we have to also exercise a touch of realism and argue that this is not just a sacrifice. It is both a moral obligation and legal responsibility that has some beneficial consequences for state populations as well. So thank you very much for listening, and I look forward to your questions.
It is now time for the question and answer session. We reserve the first question for students. Please wait for a microphone to reach you to answer your question as the lecture is being recorded. It's now time for the first question.
During the lunch are of course spot on, so I think you can just break the ice.
Hi, you talk about like climate refugees. I am very curious about that. How does that work?
The question of climate refugees is right now one of the most debated and discussed issues. One way to tackle this is, I'm telling you, the kind of work that's being done in legal scholarship and advocacy, is to try to see if there are convention categories about, the preservation of life and the basis for life, etc., that can say, of course, the climate refugee is a refugee because the foundation of all treatment accordance with human dignity must be life and the preservation of the conditions of life. So people are saying you can bring that in. Another argument is, and this get, about climate refugees, whether they would require another convention. And some are saying, look, you can't just put everything into the 51 Convention. It has enough difficulties as it is. Try to come up with a different convention for climate refugees that recognizes the specificity of climate change. And that kind of convention would involve some reflection about what heavily industrialized capitalist countries, the ones that are responsible for most of the producing, most of the globe pollution, what responsibility do they have towards other countries that are losing their territory, right? As the island of Tuvalu, I think, where there's been a case in front of the United Nations where people are saying it's not just that we're losing our livelihood, we're losing our territory. What do we do about this? So that's why I didn't want to go into, because I myself at the moment do not have very firmly formulated judgments about which way one should go. What is clear is one's obligation to do something, but how far does that obligation extend, particularly also when something like the territory disappears? Then what do? Then do you create another territory on another island, or, to deal with individual cases is different. Okay.
Hello, thank you so much. I had a quick question. So you talked about some of the cuts that U.S. has made recently when it comes to accepting immigrants, and I was wondering if any other countries have stepped in to make up that gap because it has been so large, and if you see this discrepancy in the number of refugees as causing a new global trend.
Great. I'm afraid that these trends are global. In other words, I think some countries may have more defensible refugee practices. Certainly, major countries within the EU and so on try to, but everybody is trying to come up with some nonsense, right? The UK is outsourcing people to Uganda and Rwanda. The French have, built this horrible situation right across from the British Channel. And Greece, you have an island where there are 50,000 refugees still in residence who cannot move north because Hungary had built a wall that prevents them from crossing. There isn't much that is good right now that's happening. I mean, there just isn't. And I think this is a trend towards, we are dealing with a trend towards retrenchment. And obviously, the treatment of the refugees also has a great deal to do with the anti-immigrant politics of the sort of the global right. Yeah? I mean, how's that going to change? I want to say something. I see my Turkish colleague here. I haven't said much about Turkey. Let me say something about Turkey, because Turkey is an interesting player in all of this. It was one of the major countries that Europe appealed to in the midst of the big Syrian and Afghan refugee crisis. There was a bilateral agreement between Turkey and the EU. This was a while back, that in return for every refugee that Turkey gave refuge to within Turkish territory, the European Union would be paying certain sums, etc. This was during Angela Merkel. Turkey eventually developed its own convention. And it actually, there is something interesting happening here, which has a lot to do with politics. That Turkey is one of the few countries that gave citizenship to refugees. It gave citizenship to about 10,000 Syrians. Now, this is a very mixed bag, because the minute, the 10,000 Syrians, who get citizenship status, go ahead and vote for Erdogan. This is more like what used to be called Tammany Hall in migration politics in US history. But it's also interesting because, there is a huge domestic debate in Turkey right now. But it's also interesting because there is one of the few countries that created that thing. Although the convention actually obliges countries to eventually create a path to citizenship. So I don't know what you think about this, but I wanted to bring it up because it's such a case that doesn't get discussed much. But
let's see. May I? Thank you, Professor, for the informative lecture. I was particularly glad of the fact that you mentioned the 2012 Italian situationship, because coming from Italy myself, I know that the situation there is particularly grave, and it's not very much talked about. It's quite overlooked. Right now, there's quite a big number of refugees who are being directly sent to Albania, which is renowned for having literally concentration camps for refugees right now. And the thing is, the common opinion is very silenced about it. And I was wondering what your opinion was on this, if it was related, this kind of lack of ethical discourse on it, to the enforcement and exacerbation of the political right or of the current narrations by the media. Why is there such a sedated reaction to it? Thank you.
Yeah, no, thanks for that question and for the reminder that this anti-refugee discourse has been emerging in Italy for quite some time, like with the Lega Nord. It started about 20 years ago, even before Prime Minister Meloni's party coming to power. I think that there is maybe on the part of the public as well, there is almost a kind of general moral exhaustion. Not that Italy has received that overwhelming numbers, but I think that people in general are somewhat confused about their obligations as well as the possible response. And I think, what you have to do is what I call, you have to look at the myths and facts about the issue, because there is a lot of mythologizing, right? Just as, when you look at the countries that are the most recipient of asylum seekers and so on, it's not the European countries. And Italy nowhere comes close to the number of people that, let's say, Germany or even Greece per capita has received. So it is part of this change of political constellation, and maybe maybe there will be a transformation, but it has to start here. It has to start in the United States. As long as we are setting the worst example, I'm not sure if the European countries will straighten up. I don't know.
Thank you for being here, Professor Benhabib, and for your talk tonight. I think my question follows on that point about it has to start here in the US. And my question is about how you think about the role of the Refugee Convention in the midst of genocide. What happens to the obligations of nation states who have signed that document in the face of televised mass destruction, displacement, enforced famine, enforced and created health crisis, thinking especially, as you noted on that slide, that Israel is a signatory to that convention, and yet no report from the UN, no report from Francesca Albanese, no report from the World Health Organization, no accountability. And so as you're thinking about what it means to see a collapse of the international legal order, how do you think about that specifically in the case of Gaza? And how do we think about what possibility of state cooperation and state accountability under the Refugee Convention is at all possible in this moment in time? Thank you.
Well, the Refugee Convention was always one of three, the UDHR, the United Nations Convention Against Genocide, as you know, that's still one of the strongest conventions, and it is I think that now Israel's violations of international law have reached such an incredible proportion, have reached such an incredible dimension that I'm not quite sure what instance or what will do what. I think Francesca Albanese actually is one of the very few courageous voices that's talking about the consequences of technology and of the new technology for the war, and also talking about some of the economic implications and so on of the war. But let's face it. Under this U.S. administration, it's just like Israel has gotten the kind of impunity that it never had before, and under Biden as well, right? Yeah, I think Yeah, that's a political issue. Biden, I think, may have stopped the process somewhere, but that may just be a difference of political interpretation. Look, it's the destruction of UNRWA, right? The delegitimization of United Nations Refugee Works Agency, etc., on political grounds, that there were some members who were sympathetic, to Hamas. Maybe it's possible. Why not? That's quite possible. But does that mean that an organization that was set up by the United Nations, that has its own article, etc., simply disappears? What happens to these people? Who speaks for them? Who represents them? So I'm just mumbling. I don't think I have very clear things to say.
We have time for 2 more questions.
So given kind of what's going on right now in the U.S. with our policy towards immigration, what you kind of went over with the non-entree policies was very different, and the wall policies is very different from what we're seeing right now. So I guess my question is kind of similar, like what is the role of the convention, given that we're seeing such a different immigration policy from like those non-entree rules or policies?
For some reason, I wasn't quite understanding. I don't know if it was the acoustics. Could you just repeat your question again? It really was a bit issue of acoustics. Yeah, go ahead, please.
Yeah, sorry. So given the current immigration policy in the U.S. of rounding up illegal immigrants and detaining them and deporting them is very different from the non-entree policies that you talked about and the wall and border walls and everything. So what is the role of the convention in that circumstance?
You are referring to the current administrative measures being taken by ICE, etc.
Yes.
Okay. First, the stipulation by the U.S. government that refugees have to arrive in designated ports of entry is nowhere justified by the convention. I mean, I am looking in the literature for something that basically says this idea of a designated port of entry is number one. That doesn't make any sense. The other, or it is against the convention. The other issue is, of course, what you're pointing out to, is the criminalization of individuals who are present in the country and whose status is constantly, I mean, there's so much that's happening. There, you have people who are being arrested for showing up at their interviews, for crying out loud. Okay? And how can that be anything but an illegitimate act? And the courts are fighting it. Or in so many cases now, immigration judges are under awful pressure. I don't know, I was reading a big article in the New York Times today about 3 judges that have been removed, and one of them knew she was going to be removed because statistically she admits about 68% of the applicants, and that above 38 is not acceptable, and she no longer can have the position of being an immigration judge. So what we have basically under Stephen Miller's policy is a total assault on the legitimacy, on the system of refugee, and not just refugee and asylum, but also immigration, right? I mean, the criminalization of undocumented or being out of status is the term that I prefer, because you can become out of status not because you're trying to break the law, but for many, many other reasons. But what has become successful as a discourse, or let's say what they're trying to make successful as a discourse, is to look upon being undocumented, as my friend Ayala Shahar says, it's as if it's an original sin, right? And it's as if that original sin can never go away. I mean, suppose you were dumb and you didn't renew your passport. Or suppose you fell in love and you didn't want to leave the country. Suppose you got pregnant and you didn't want to leave the country. I mean, is there no way to deal humanely with these situations other than to paint these individuals as criminals, as subhuman? I mean, we just have to be very careful there. These are political ideologies. We must know this from the 20th century if we learned anything about othering the group, othering a group, and assigning to them this or that characteristics, right? Because, yeah, I mean, the issue of undocumented, it is a question. You know, there may be ways of dealing with it, and there were ways of dealing with it, okay? Create general amnesty. Tell the people who came in last, that you're going to go to the end of the line, you're going to wait 7 years, 8 years, you're going to pay this much, you're going to pay that much, or you're going to prove the family conditions. You know, I mean, right now, DACA, you know what DACA is, right? Deferred Action Childhood Arrivals. Right now, you know, Trump isn't touching that. He likes DACA, right? But create a situation like DACA for everybody. Why is that such an unsolvable problem? And it isn't. It isn't. And I'm going to say one more thing now. I'm going to go on a little too long. I'm sorry. Another side of the argument is always about the labor market, right? What makes some of this discourse about migrants, and now we're not really talking about refugees, which is still a smaller group among the migrants, are the questions about economics and labor migration, right? In the minds of a lot of people, migrants, lower wages, put pressure on wages, take away jobs, and in general are not good for the domestic workers in the economy. Yeah? Guess what? I mean, you know, one has to read the Wall Street Journal, which I don't regularly do, but on this question they're right. There are entire labor sector jobs that are not going to be taken up by American citizens. They're not. And I don't know why that's the case, but we can discuss it. We can talk about it, why people are not going to go to the California strawberry fields. Whereas, you know, if you create a humane migration policy, there will be many Mexicans and others who will come. So this whole discussion also about migrants and labor, it's also not quite accurate sociologically. And this goes also to countries like Italy and so on, where nobody quite knows how these niche labor market issues are working out. So that's another argument to try to create a kind of, you know, amnesty. This is not rocket science. It can be done if there is a will.
Hi, thank you for coming to speak with us. I think my question is kind of related to that last point. I feel like there's so much pushback from governments to the legislation that we make them follow. And I was wondering what you think we can do outside of what we write and the rules we make to motivate and the US and other countries to want to accept refugees rather than to want to push them away?
Well, I mean, to me, it's just unbelievably impressive what happened in a place like, what happened in, Minnesota. We have to learn from that. And I've been thinking about this new kind of ethic of neighborliness. This is something, it's not new. I mean, the category of the neighbor is not new, but that the creation of a whole movement and network of solidarity around it, that people would voluntarily care for each other's children, that they would bring food, that not only would they, of course, warn ICE coming, etc., but yeah, I mean, that people were ready to die for others. I think that this is there in this country. I think that a lot of, it is there in communities. We have to activate that. Look, maybe there is a lot of remnants in Minnesota also of the Black Lives Matter movement, right? There's also a little bit a question of understanding, the sociology of social movements, how do acts of solidarity grow. I think they make a tremendous difference. I don't think this is just naive. ICE is no longer just, so omnipresent in the cities. There's still there's a toning down of some of these efforts, but they're still going on. One other issue I want to mention is the establishment of detention centers along the Texas border. There was an item of news that before Secretary Noem was let go, she had been part of some negotiation where a huge amount of acreage was purchased in order to build detention centers for migrants. That must be an absolute no. We have to speak up about that because, as I learned from Arendt, you never know for whom those detention centers will be. They just should not be built. Okay. Appreciated your questions.
Yes, this is from